No evidence was adduced to show that the first accused person failed to comply with Section 50, subsection 1 of the Public Finance Management Act as read in Regulation 26(1)C of the Public Finance Management (National Government Regulations) of 2015. No evidence was adduced to show that the first accused failed to comply with Section 50, subsection 6 and 7 of the Public Finance Management Act. On the charge of knowingly giving a misleading document to principal, no evidence was adduced to show that the eighth accused person gave a misleading report to anybody, and no such report was placed before this court. On the charge of neglect to perform official duty contrary to Section 128, as read in Section 36 of the Penal Code. On this charge, I'm in agreement with the submissions of the ninth accused person, and also the evidence of PW2, who is the compliance officer at NEMA, as there is nothing to show that the process of issuance of the license was done in an unlawful or unprocedural manner. It was a testimony of PW2 that he prepared that the report is prepared by consultants hired by the KVDA, and that the license that was issued to the proponent underwent various departmental reviews before it was signed by the Director General, the ninth accused. PW8 confirmed to the court that the licenses issued for the Aror and Kimwarer multipurpose project was conditional, and that the license issued was not a ticket to construct. He highlighted those conditions of the license. Which required that there must be adequate compensation for all those people who are to be affected by the dam project. And to this end, the ninth accused person followed the due process and issued a conditional license to the proponent. As to whether those conditions were followed was not part of his mandate, and therefore it has not been demonstrated that the ninth accused person had any role to play after this. And lastly, I wish to comment on the conduct of the prosecution counsel. In the instant case before me, the prosecution called a total of 49 witnesses. In a strange twist, the prosecution only led evidence from 8 witnesses. The rest of the witnesses, numbering to 41, took to the witness stand, were sworn, and thereafter the prosecution declined to examine them, claiming that they did not have questions for this witness. This would appear to be a carefully choreographed prosecution-led acquittal. The court in Bitangendemo versus Director of Public Prosecutions held that statutory power donated to any organ is not to be executed in an unreasonable manner. In making this decision, the court relied on the case of Republic versus Commissioner of Cooperatives, ex parte Klinyagati Growers Cooperative Savings and Credit Society, where the Court of Appeal warned, and I quote, it is axiomatic that statutory powers can only be exercised validly if they are exercised reasonably. No statute ever allowed anyone on whom it confers power to exercise such power arbitrarily, capriciously, or in bad faith. In Nairobi miscellaneous application number 1769 of 2003, Republic versus Ministry of Planning, and another, ex parte Professor Mwangi Kaimeni, it was held, where a body uses its power in a manifestly unreasonable manner, acted in bad faith, refused to take relevant factors into account in reaching its decision, or based its decision on irrelevant factors, the court will intervene on the ground that the body has in each case abused its power. The reason why the court has to intervene is because there is a presumption that where Parliament gave a body statutory power to act, it could be implied that Parliament intended it to act in a particular manner. In their opening statements, in the matter before me, in their opening statements at the start of this trial, The prosecution made an elaborate speech, opening speech, and highlighted how they would go about proving their case. The prosecution counsel, Mr. Tai, had this to say, and I will quote: "The genesis of this matter arises out of two projects known as Aror and Kimwarer multipurpose projects, dam projects. We will demonstrate to the court that the accused persons conspired and committed offenses they are accused of, as they primarily used these projects for their enrichment. We will show that it's not only 65 billion shillings that they plan to steal. Government of Kenya has been exposed in excess of 8 billion with the when contractors are actively pursuing the collection of arbitration in court. And they seem to collect even though there is no dam on the ground. The fact of the matter is that the cabinet minister approved only one dam, that is Aror Dam. It did not approve construction of Kimwarer. Even approval of one was on the basis of the government would not be funding the project and that KVDA was to source for concession agreement, which the person identified will arrange for the design, development, build, operate, transfer project government of Kenya, financing and recompensing the finances for operating the project. What happened was that the accused persons conspired and managed to float tenders for both projects and awarded the project to a company known as CMC Ravenna Itinera Joint Venture. These projects were awarded by accused persons in breach of all known laws in procurement. That company did not even exist at the time of the award. We will prove that CMC Ravenna never brought or acquired any tender document. The company did not submit any bid for construction of the two dams. It was not one of the companies forming the record at the opening of the tenders for the two projects. It was not considered and did not form part of the tender evaluation committee. CMC Ravenna was not even a recipient of letters of acceptance from any of these two tenders. And due to impropriety and pure corruption, they were granted two tenders in the amount of in excess of 65 billion out of thin air. Mr. Taib went on to state that there was breach of procurement laws which demands that before tender there must be a full budget for procuring entity. There was no procurement plan as is required by law, and we will demonstrate that PPDA 2004 was contravened. And he goes on and lists all the kind of things they were intending to prove before this court, which I have listed herein. And in the end, he says we will demonstrate that it is the actions of the accused persons constitute offenses. And he says we will prove through trial through evidence the impunity is calibrated. Because when they are in power, they never believe they will leave power. End of quote. This is what Mr. Taib said in his opening statement at the beginning of this trial. However, 8 witnesses later, this tune suddenly changed. The prosecution was no longer interested in prosecuting the case. They informed the court that they had firm instructions not to proceed. As such, this court only relied on the evidence of 8 witnesses. In the case of Republic versus Director of Public Prosecution, ex parte Kamami, otherwise, the prosecution will be malicious and actionable. I am further guided by the decision of Justice Sifuna in the High Court case number E044 of 2022, where he held, and I quote, there is need to check. He held that there is need to check the unfortunate and reckless habit of the ODPP of commencing proceedings Such conduct is an affront to the administration of justice and a waste of precious judicial time. It is an insult to the dignity of the court and all the stakeholders involved in the criminal justice system. Indeed, as Justice Sifuna held, such officers from the Office of Director of Public Prosecution should be personally held liable for any compensatory damages arising out of suits filed by aggrieved persons against the government. As such, I hereby order that this ruling shall be placed before the Attorney General and the National Council of Administrative Justice with a view of sparking conversation on legal reforms on this issue. In the meantime, all the accused persons herein are hereby acquitted under Section 210 of the They are hereby acquitted and all due to lack of evidence as a result of the reckless dereliction of duty by.
Thank you, Your Honor. We are most obliged. We apply that we be supplied with a certified copy of the court's decision. I apply on behalf of the first and the sixth accused person that the monies they deposited for bail be refunded to them forthwith, and the passports deposited with the court be released to the accused person.
Your Honor, Nyutu for the second and third accused. Your Honor, as regards the third accused, there are three title deeds that were deposited in court by three individuals to enable him travel. They were not part of the security for bail. They were deposited on the 2nd of December 2019. This is title number Muguga stroke Gitaru stroke 3118 in the name of Bernard Mwaura Kamondo. The second one, Your Honor, is title number Kiambu stroke Municipality Block 5 into bracket Kiamumbi 1584 in the name of Emily Wamboi Kamondo 1584 in the name of Emily Wamboi Kamondo. And the third one is title number Kiambu stroke Waguthu stroke 3419 in the name of George Ngaruia Maracha.
We request for release of his the titles that were placed as security as bond on his behalf, and the release of his passport. Gratitude for the decision that has been arrived. Thank you very much.